Richard Deitz, CEO of VR Capital in Ukraine, to share some of your experiences. Richard, please.
Good. Thank you very much, Andy. And I think I'll start first just by adding my voice to the others to say that we really appreciate and value the work of AmCham in the U.S. Chamber in these areas. We appreciate the dialogue, the partnership, and the advocacy that helps us as investors invest and navigate the challenges that occasionally we run across in the course of our investment. I think I could contribute best to this dialogue by giving a case study to take some of these issues that we've discussed, to take some of these issues that have been discussed today and really boil them down to what does it mean through the eyes of an investor? How does it affect investors in the real world, and for better and for worse? At VR Capital, we're one of the largest and longest-standing foreign investors in Ukraine. We have over 20 years of history of investing in Ukraine. And in particular, we took a very important decision about 6 years ago to significantly ramp up our investments. We took that decision at what was really the most challenging moment for Ukraine. During the protests on Maidan and the very difficult events that followed with the annexation of Crimea and the war in Donbass, at a time when the Ukrainian economy went into crisis, there was widespread fear about the future of Ukraine. We, having been here at that point for almost 15 years, we also perceived along with that a very significant change in mentality in Ukraine. And we saw that, and we took the kind of contrarian view that this was really an opportunity for Ukraine to significantly transform itself and to make the breakthroughs that have been so difficult to make for almost through 20 years of independence. And that the existential threats and the pressure that it was under really had motivated a whole new generation of Ukrainians to come out and insist not just on democratic rights, but on reform and on a different course for Ukraine. And it was something that we thought we really wanted to be a part of and support. We're a bit of an unusual investor in that we're kind of a hybrid investor. We invest both in the real sector and we operate real businesses in Ukraine, and we also operate in the financial sector where we're a provider of capital to Ukrainian companies, to private companies, and also to some state-owned enterprises. In the real sector, we've built the largest foreign-owned renewable energy business in Ukraine. We've built from greenfield over the last 3.5 years, 30 wind and solar parks spread across the country in many different oblasts. We have over $1 billion invested in Ukraine. And I have to say, recently, we've put on hold over $400 million of additional investments that we have for programs within the renewable energy sector. And it's unfortunate because without going too deep into this, the renewable energy sector in Ukraine is a new sector. And if you look at it on kind of a global evolutionary scale, it's maybe like a 1.0 or a 1.1 in terms of its sophistication. There's a lot of further steps that need to be taken to realize the full potential of renewable energy for Ukraine in terms of private-to-private contracts to take the state completely out of the business of being an off-taker, to invest in flexible generation and battery storage so that renewables can go from being an intermittent provider to more of a baseload provider. And that's a series of investments we have of over $400 million that we've identified. And unfortunately, we put that on hold in recent months. So why did we put it on hold? It comes out of rule of law issues that we've encountered. Not in the renewable sector, but in the financial sector investments that we make. And so I'll tell you briefly about that, and I think it's a good example. About 2.5 years ago, we made the largest purchase of a non-performing loan in the history of Ukraine. We bought this loan at an auction. It was a public auction. It had multiple bidders. The auction procedures for the bank, it was a Ukrainian bank that sold the loan. The procedures were approved by the National Bank of Ukraine. The auction was conducted in public, and it resulted in the highest realization ever for an NPL sale in Ukraine. It was a $123 million purchase. The borrower on the loan was Ukrainian Railways, a state-owned company, the largest employer in Ukraine. And the lender was a Ukrainian bank. Our intention in buying the loan was to do something that we had done multiple times before in Ukraine, which was to negotiate a debt restructuring with the borrower. And in particular with Ukrainian Railways, that was a borrower with whom we had negotiated a restructuring of their Eurobonds on a consensual basis that solved one of their problems after the Maidan, after the Revolution of Dignity. So it was a company that we knew, it was a management that we knew. And unfortunately, after buying the loan, despite all efforts that we made to reach an amicable debt restructuring, our efforts failed. So what did we do? We went to court. We went to court because the company was continuing to pay all of its other creditors, and they uniquely were refusing to pay us. And we went to court, and I can start with some positive news. We won. We went to court and we asked for performance under the loan agreements. We went to the district courts. The district courts affirmed our rights. It went to the Court of Appeal. The Court of Appeals affirmed our rights, and we went to the Supreme Court. And the Supreme Court also affirmed our rights in 6 different cases. There were multiple loans. Each one of them had a different case. So 6 different times, our rights were upheld by the courts at every instance. But we found, unfortunately, that the largest state-owned company in Ukraine would not abide by the Supreme Court rulings of its own Supreme Court. And instead, what happened was a transformation of this case into a massive administrative pressure. So for one, a criminal case was started. A criminal case was opened by the prosecutor's office in the company against my company and against the bank that sold us the loan. Now, they sold us the loan in an open auction, an auction that was approved by the National Bank in a completely legal fashion. But they said that the criminal case said that we conspired to inflict economic damage on Ukrainian Railways. Really makes no sense. They were a borrower. They had to pay one party. They didn't pay that party. The party sold it to another party. They still had the loan. It was purely an act, which happens all too often, of using criminal processes to try to put pressure on investors and to try to put pressure on private sector actors. And then the company sued 2.5 years later, after we had purchased the loan and after we'd been through 6 cases all the way to the Supreme Court. They filed a suit in which they tried to invalidate this purchase, which had happened 2.5 years later. Now, you might ask, that agreement was a private agreement between us and a seller. Why does a third party even have the right to try to invalidate that transaction? That's maybe a good question, but in any event, they brought this case. At the same time, we had some negotiations with them after they lost in the Supreme Court. They did start some negotiations. And I was invited to Kiev in July to have a meeting. And the purpose of the meeting, I was told, was to find an amicable resolution, an amicable financial settlement of this issue. The meeting took place in the office of the presidential administration. I had the Minister of Infrastructure, I had 2 deputy heads of the presidential administration, and the CEO of the state-owned company. Without going into detail, I can say that the meeting, from the very beginning of the meeting, it was quite clear that there was going to be no serious attempt made to resolve the issues. And instead, in the meeting, the legal advisor to the president said to me, he said, listen, Richard, you know something I have to tell you. The lawyers that you've hired for this case, they're excellent lawyers. I know them. I used to be in private practice. They're outstanding lawyers. Furthermore, you have very good legal arguments. Your case is a good one. He said, but you should understand one thing. In Ukraine, judges can be fired. Judges can be dismissed. Didn't quite know how to react to that other than to say, well, listen, this is, if you're telling me that that's how things are going to work in Ukraine, I have to put my investment program on hold in the country. I can't continue to invest and underwrite investments in a country, in a system where I can't count on the rule of law. And from the time that meeting ended, I have to say that legal advisor to the president has been a man of his word. We have seen major interference in the legal processes. We had a case that went to the Court of Appeals in one of their 26 different cases related to this one particular issue. And in the case that went to the Court of Appeals, when it came time to draw by lottery the judges, there's 54 appellate judges in Ukraine, and they should draw them by lottery, we were informed that 51 of the judges weren't available. They were on holiday or they were sick. So out of the 3 remaining justices, they selected the 3 remaining justices. That included a justice who was currently under criminal investigation. It was clearly a handpicked set of judges. And we understand where the pressure to do that came from. When it came to this challenge that Ukrainian Railways made to our purchase and sale agreement, we went to a court of first instance, we won. Then it went to the Court of Appeals. Just before the 11th hour, just before our appellate court hearing, one of the judges was replaced. The judge was replaced by one of those 3 justices who happened to be not sick or on holiday when a different of our cases required selection of an appellate panel. We were never notified of the appellate court hearing. Our lawyers found out about the hearing, they went to court, and they showed up in court, they hadn't prepared papers, and they said to the court, listen, we never received notice of the hearing, could we postpone for 2 weeks? You're supposed to give us by law 2 weeks notice. The court said, listen, we're very sorry, this is hard to, truth is stranger than fiction sometimes. The court said, we're very sorry, we ran out of postage stamps. We weren't able to send you notice. But why don't you come back tomorrow morning? We won't give you 2 weeks, but come back tomorrow morning. Our lawyers wrote a 68-page brief overnight. They came back without sleep. They came to court the next morning. They submitted the brief, and they asked the court, can you adjourn for 48 hours so that you can read our papers? The court said, no, we don't need to read the papers. We can just have oral argument. We had 1 hour of oral argument. The judges said to the courts, to everyone there, sit tight. They left for 2 minutes. They came back 2 minutes later and delivered a verdict against us. The next day, they issued a written opinion. And to write a written opinion, they should have read our papers. It's quite extensive. Someone should have written the opinion. It should have been circulated amongst 3 justices. They should have made comments on it. They should have reconciled their version. There's no way that decision could have been written in 24 hours. It's very clear to us. The decision in our case was written before our hearing happened, and it wasn't even written probably within the court because it followed the same syntax and even the same misspellings as the submissions from Ukrainian Railways. And so that's a reality. We have that case on appeal to the Supreme Court right now. So the story isn't over. We hope at the Supreme Court level, we won't face the same kind of political interference, that we'll get a fair hearing and fair consideration. And that's what we ask for is what any investor rightfully asks for. We don't ask for favors. We don't ask for special treatment. We just ask for equal treatment, and we ask for the law to be applied in a fair way. And if we can do that, we can invest. We can't do that, we run into the problems, and as Kendra said at the beginning, and pointed out, there's 118 countries, I think, on that list. It's 118 different places that we and other investors can invest. And we want to invest in Ukraine. We really love this country. We really think it's a country with enormous potential. But those are kind of the reality, for better and worse. As I said, this isn't all a bad story. We went through enforcement proceedings against a state-owned company, and we won in every case, and we clearly had fair trials. But then we ran into something different, and that's kind of, I guess what I'd say is the good and the bad and the challenges that we and other businesses face here in Ukraine.